Hello, everyone, and welcome to Estate Planning During a Financial Crisis, presented by the Jason Howell Company. And I'm here today with Dave Knasel. Hey, Dave, say hi.
Hi, Jason. Hi, everyone. Thanks for joining us today.
Excellent. And I'm going to now, you're going to see my eyes switching every once in a while. I'm going to start admitting folks in so they can see our pretty faces and they can be a part of our big show today. Welcome everyone from Zoom land to Estate Planning During a Financial Crisis. Some of you know David already. We're so excited to have him for this important discussion around estate planning, especially at a time like this when, from what I'm hearing from Dave, a lot of people are sort of rushing to his door, his offices over at Protorae Law to essentially get their affairs together. Not that there was never a good time to do this, but now people are starting to think about their mortality and a whole bunch of other stuff. All right, as I'm getting forward here, I'm going to ask David. David, how was your day today? Just tell us, how busy was it? What were you up to? Bring us into the room here.
Absolutely. Thank you, Jason. So yes, it's been a busy day, and it's been a busy, couple of months actually overall. But today in particular, this is the second of three Zoom sessions that I have scheduled today. For some reason, everyone wanted to schedule them on Wednesday. And then, so in between those, I'm also working on finalizing some estate plan portfolios for clients that have recently completed their estate plan, and we're kind of putting it all together in a nice package for them with all their documents and additional information that they need. And then also I'm working with a few business clients for, their different business documents like operating agreements and leases and things like that. So a lot going on as always.
Are you tired? When did you start your day today in the office?
About 9.
Okay. All right. So, COVID-19 pandemic, you start at 9, no difference for you.
Right.
All right. Well, thanks for being here. And I see a bunch of other folks have kind of jumped on here. So we'll get started, I guess, in the next few seconds. Just FYI to everyone here that's on the conference with us, if you have any specific questions for David, of course, you could interrupt him and throw off his flow if you'd like. But really, that's what the chat is for. We have a group of questions that I think is going to be relevant to almost anyone that's thinking about estate planning in any way. But if you have specific questions, go ahead and put them in the chat. I will certainly get to them before we jump off the call today and allow David to answer your questions live here on Zoom and Facebook. All right, and every once in a while, you're going to see me sort of looking over to the side and admitting folks in. So don't be thrown by that. But right now, I will go ahead and share our presentation with everyone. And now you can see a gorgeous photo of Mr. David Knasel and an okay one of me. So welcome once again to Estate Planning During a Financial Crisis. We have the Honorable David Knasel here with us from Protorae Law. David has a couple of different specialties, and his firm has a bunch of specialties as well. But overall, before we get into the entire presentation, I want to thank you for joining us. Jason Howell Company has been presenting some of these Zoominars, I guess, over the past few weeks, and we have plans to continue doing this over the next few weeks as long as people continue to be interested. What we're doing is having conversations with people who are the kinds of folks that we would typically refer as a general wealth management firm to really bring some expertise in, people that are licensed, that do what they do for a living, so that we can do what we do for a living for our clients, and everyone is getting excellent service. And so we're really happy to have Dave. I think it's one of the required pieces of a comprehensive financial plan is to have an estate plan, and especially having someone that's licensed in your state to work with you. Okay. David, if you would, just give us an overview of Protorae Law. I know you had your own firm before this. Why did you choose to join this firm? And really, what are they doing during the pandemic to make themselves accessible to people?
Yeah, sure. Thanks, Jason. Everyone, my name is Dave Knasel, and I'm a member of Protorae Law. and I head up the Trust and Estates practice group of the firm. The firm has been in existence for about 10 years and is primarily focused on representing businesses and business owners. And that is across a wide array of different legal services that those clients may need. That includes employment law, corporate law, government contracts, litigation, intellectual property, and pretty much most things that a typical business is going to need in the way of legal services. And then my area, the trust and estates, is more on the personal side. However, I work with a lot of business owners, both on their business legal needs, as well as on their business succession planning, which is kind of the tie-in between the two areas. Business succession planning, basically in a nutshell, is a plan for what's going to happen to your business if you are incapacitated or pass away or certain other circumstances happen. And as we can all imagine, that is something that has really become a top concern for a lot of our business clients, as they wonder, how this quarantine is going to affect their business. And, God forbid, if they, contract the virus and are not able to work or manage their business, how can their business survive that?
Terrific.
So you also asked about, how we're dealing with the COVID pandemic. So, I mean, I guess just from a physical standpoint in terms of our building and office space, we have masks and gloves and hand sanitizer and disinfecting wipes to wipe down surfaces. Our building has marked out areas on the floor for waiting for the elevators and, limited capacities on the elevators. There's very few people here. So it's actually quite easy to practice social distancing. Obviously, like many people, we are doing the majority of our meetings with clients by telephone, video, email. And however, we can meet with clients here in the office when it's necessary. And one of the main reasons why it may be necessary is for estate plan signings. Typically, you need witnesses and notaries and those kinds of things. So typically, we do those in person. The state is moving towards virtual notaries for certain things. However, it's not all the way there yet for estate plan signing. So we've been doing those in person, but we have a very large conference room where we can, be 12 feet apart from each other. And we even—
You've doubled it up, 12 feet. That's even safer.
Right, exactly.
Right.
We're lawyers, so we like to be extra safe.
Excellent.
And we even had one estate plan signing that we did outside.
Okay. And then now the weather's getting so much better, you can more easily do that. Well, thank you. We're going to get to your presentation and give you a proper introduction in just a sec. But thanks for giving us a little bit about Protorae Law. For those of you who are not as familiar with Jason Howell Company, we are a family wealth management firm. What we like to do is take the best of the ultra high net worth folks and bring that down to sort of our Washington, D.C. metropolitan level. I call that regular net worth. Our job is to empower families to make decisions about the special things they want to do with their money, both for their family and maybe for a passion project, maybe for some of the social justice issues that they're interested in, as we are all living in this very, very difficult time with the pandemic and with riots and with protests, all for good reason. And so a lot of the people that we work with, they have real reason to set aside money, not just for the modicum of what they want to get done, but for big, important things. That's what's pretty typical about the people in the Washington, D.C. area. We're, of course, very proud as a firm to be recognized in a couple of different ways, been on television a little bit and in the paper a little bit. Both of our principals, myself and Doug Tees, are certified financial planner professionals, which is a big benefit to the folks that we work with. And we're continuing to find ways to add value to people that are really trying to do something special with their money. So that's a little commercial about Jason Howell Company. As I mentioned before, we're having a good time putting these presentations together with other experts within the area that really bring the mind share to help our families make those great decisions. All right, without further ado, I'm going to introduce Mr. David M. Knasel more properly. So happy to have him here. You know, he's a UVA grad through and through. He's from McLean, so he's a Virginia guy. I know he's licensed in Virginia. David, are you licensed in DC and Maryland as well?
Yes, I am.
All right, so he's got the whole metropolitan area taken care of. And man, you know, I tried to think of like a bullet point that would be something fresh and new, even for some of your colleagues that may be here on the line. Give us one little nugget that that most people don't know, maybe something you enjoy or some way you like to spend your time.
Yeah, well, I guess, you know, one thing maybe people don't know is I was actually born in Germany and lived there for the first 6 months of my life before we came back to the United States.
Wow. Okay. A wonderful nugget. Thank you very much.
Virginia native, as my brother likes to remind me.
Oh, what native? I missed it.
Not a Virginia native.
Not a Virginia. 6 months out. Was it an Army base you were born on?
No, my father was doing research at a university in Germany.
Okay. All right. So there are multiple layers. You'll note David's contact information is right here. So if you would just want to email him about his time in Germany and what the heck his dad was doing, you can certainly do that. We have a couple questions in the chat already. So I wanted to get to that just before we go with our standard questions to let people know that we are watching the chat. So David, our first question is, what sort of recommendations do you make to those clients who wish to ensure they can retire in dignity, affording ever increasing housing and health expenses while leaving whatever remains to their family members?
Yeah, well, I guess the first thing I would say is make sure you have an outstanding financial advisor like Jason Howell Company, featuring Jason Howell and Doug Tees, because in order to accomplish those goals, you're going to need the finances to pay for it. And then where the legal side of that comes in is, you know, having the documents in place to have the people that you want to be the decision makers making the decisions and having your wishes expressed so that you know that those will be carried out and you can be cared for in the way that you want to be cared for, you know, live the way you want to live and pass on the legacy that you want to pass on to those to whom you want to pass it.
Terrific. And that's probably a lead up to our very first, very broad question. A lot of people, I think, on the line have a great sort of overall understanding, but maybe you can give us just sort of a little bit of detail and elements of what estate planning actually is.
Yeah, well, obviously, I just kind of alluded to it. So estate planning, in a nutshell, is designing and creating and implementing a plan and the associated legal documents that go with that to make sure that you have the people that you want making the decisions for you if you're not able to, and you have your wishes carried out in the event that you're incapacitated regarding your medical decisions or your financial management, and of course, following your death.
Okay, so it's not just a will, there's stuff for when you're alive and then also stuff for after you've passed away.
Correct. And I'll also just emphasize here, you know, what I touched on before, which is that it's important that your estate plan work together with your financial plan. You know, they are kind of two sides of the coin and they need to work together. So that's why it's so important that your advisors you know, be in good communication with each other and you really have a good team supporting you.
Oh, terrific. Certainly agree with that. Now, you touched on it a little bit with Protorae and some of the things that they're doing to essentially have PPE, you know, protective gear for their clients. Are there other structural changes in and around estate planning during the pandemic? Maybe you could speak to the volume. Have there been any changes because of the pace of people wanting to put plans together?
Yes, so absolutely. So we've been, you know, as busy as ever, if not more so, during this period. And a part of that, I think, is because these types of issues have come to the top of mind for many people. And then on top of that, they have, maybe been stuck at home for a prolonged period and are finally getting around to, getting their affairs in order or checking some of those items off of their to-do lists that have been lingering there for a long time. So we are definitely, seeing people that are, now sort of more interested than ever in getting their estate plan done. And B, we're also seeing, with some clients, there's more of an urgency to get it done faster because of this situation. And I've already kind of talked about some of the procedures that, we're doing as far as how we're meeting with clients and that kind of thing.
Okay, yeah. Well, step us back a little bit, because maybe one or two people on the line don't have an estate plan at all. So what happens to them, really to their stuff, after they pass away and their decisions if they don't have an estate plan in place?
Yeah. So, one way to look at it is if you don't create your own estate plan, you still have one. It's just provided to you by the law. And so what that means is if you haven't created your own estate plan, then a court is going to decide who makes decisions for you, who administers your estate when you're dead, who's going to take care of your children if you're dead or not able to. And then your property and assets are going to be distributed according to the law rather than according to how you wish it to be distributed. And if you have kids, they're going to inherit anything when they turn 18 and have free reign to do whatever they want in terms of spending that or, managing those funds. And also, you're essentially going to be saying, I want to pay the most amount of taxes and expenses on my estate as possible. So that is, not necessarily a desirable, default plan to have. So that's why we emphasize the importance of creating your own estate plan that reflects your wishes.
Makes sense. And it sounds like you've touched on a little bit of what I believe to be that probate process and that guardianship. Give us a little bit of color around, what is probate and what is guardianship, I guess, according to the courts.
Right. So probate is essentially the court supervised process of administering an estate. And so, what that means is if someone dies, whether they had a will or not, there's going to be potentially a court supervised administration of the estate, which means you have to file inventories with the court system and then periodic accountings, and there's fees associated with those and probate tax. And then so guardianship is essentially a similar type of process, but that's for if you're incapacitated, and you don't have an estate plan in place that says what happens then, your family may have to go to court to get a guardian appointed for you to take care of you, manage your finances, that kind of thing. And again, that's going to be a court proceeding that involves lawyers. That's expensive. And then there's going to be ongoing burdens in terms of accountings and, information that has to be filed with the court. And all of that is also a public record.
Okay, so that kind of answers the other questions too, right? Why I want to avoid probate and how do I avoid it? I guess the simplest answer to how do I avoid it is work with someone like you.
Right, absolutely, yeah. So exactly. So describing the probate and guardianship process, tells you a lot about why you want to avoid it. But I can just elaborate on that a little bit. So, there's kind of four things that we're trying to avoid. One is the delay and time it takes to go through the probate process. Two is the expense associated with, either attorneys or other advisors, the fees that the court itself charges. 3 is the burden and hassle on your family to have to, go through all these procedures. And 4 is the public nature of the process and the documents that get filed. So those are the main reasons why you want to avoid probate. How do you avoid it? Yes, talk to someone like me, create your own estate plan, and in particular, an estate plan that includes a revocable living trust, is essential to avoid probate, preserve privacy, and also accomplish many other objectives.
Can you spend about 30 seconds on that revocable living trust? Tell us, how is that different from just having a will, and what are the pluses for having one of those?
Sure. So if you want to go to the next slide, I think that would help sort of illustrate it. So this is a diagram that's showing the various components that go into a typical estate plan. And it's broken down by what I call phases of life. So going from the left, you're alive and you have capacity. That means you can make your own decisions, sign legal documents. And then moving to the right in the center area, you may become incapacitated. So you're still alive, but you can't make your own decisions. And then eventually, of course, we are all going to pass away at some point. And so to your specific question, towards the bottom there, you see the last will and testament, and then the last item is a revocable living trust. So a will only talks about what happens after you die. So it has nothing to do with while you're alive. The revocable living trust is the only one that kind of covers all 3 zones. And so basically the way that works is you set up a trust now while you're alive and while you have your mental faculties. And that trust has 3 roles associated with it. There's the person that creates the trust and contributes assets to it. That's what we call the grantor. There is the person that's in charge of managing whatever assets or property are put into the trust. That's what we call the trustee. And there is the person that, or people that are entitled to receive the income or benefit from the trust, and those are called beneficiaries. So you create the trust, and so initially you are serving in all 3 capacities of your own trust. You are the grantor that creates it, you're the trustee that manages it, and you're the beneficiary of it. Now, at some point, in the future, you may become incapacitated. So then you are no longer able to manage it, so you can no longer be the trustee. So you would name who you want to be the successor trustee. But you're still alive, so you are still the beneficiary. And so the trust document would have instructions to the successor trustee that you've named, telling them essentially use these assets to make sure that I'm taken care of and well provided for, and able to live a dignified life the way I want to, and for a lot of people that means they'd like to continue living in their home if possible. And then at some point in time, we are all going to pass away. And so then at that point, you're no longer the trustee, obviously. And so your successor trustee is still managing it. But then you are no longer a beneficiary either. And then you've named who you want the beneficiaries to be. And you can have extensive provisions laying out how you want your trust to be distributed, who you want to benefit from it, and any sort of conditions that you want to put on that. So in terms of how that avoids probate, so if you didn't have a trust and you only had a will, any assets that are passing to your beneficiaries under your will are going to go through the probate process. When you have a trust, any assets that you've put into your trust or that you send into your trust by a beneficiary designation, for example, on a life insurance policy, you could name your trust as a beneficiary of a life insurance policy. That would automatically go into your trust upon your death. So those assets are not going to go through the probate process and your trust does not get recorded in the courthouse like your will does. And so that's going to remain private and outside of the probate process. And instead, your trustee is just going to administer it according to the instructions that you've laid out in your trust document.
Wow. Okay. So thank you for getting into the weeds there, because I think some people, when they join a webinar like this, they do want a little detail, and it does really help to get that. So there's a big difference between what you get with a will and what you get with a trust. And I imagine there's a slightly difference, maybe not slightly big difference, right? That doesn't make sense, but just a plain old big difference between the cost, right, of putting together just a will versus a revocable living trust.
Yeah, that's true. So, obviously, creating an estate plan that includes a trust is more expensive on the front end. Of course, the goal is that it's going to save not only money, but time and hassle later on in the future for your family, by avoiding probate, as we've talked about. But it is more expensive. And I'll just add a little bit more about in terms of the cost. So we typically do estate planning on a fixed fee basis as kind of a package. So your estate plan package is very often going to include these different items that are shown on this chart. And so we will talk with you, find out what your situation is, what your needs are, and then, come up with what we recommend, and then, what you want. And then based on that, we will determine the fixed fee for the estate plan package. And that's going to vary from client to client, depending on how complicated their situation is and, what specific elements or features they want to include in their overall plan. And there are, a lot of different potential options that clients can select. And so we go over those with our clients on the front end to, come up with the fixed fee that we tell them, upfront, so they know basically exactly how much it's going to cost for, the specific package that they're selecting and the specific features.
Okay, got a few questions coming up here in the chat. Here I go. If assets are held as tenants in common or joint tenants with rights of survivorship, are they transferred automatically to the surviving spouse?
There are in Virginia kind of three ways to hold title to property, and the question mentioned two of the three, so I'll just go through those two and then the third. So tenants in common basically means that, and I'm just going to assume two owners, although it could be more than two owners, but just to simplify, that the co-owners each own their share, and so it could be 50-50 or 60-40 or any allocation between them, and each of their shares is separate property to them, and they can leave it in their will or trust or however to their heirs or selected beneficiaries, and it does not automatically pass to the other joint owners. So in contrast to that, joint tenants with right of survivorship is when you have co-owners that each own, they own it together jointly, and if one owner dies, then the remaining owner or owners become that the deceased person's share automatically passes to the surviving owner or owners. And then, so the last form of ownership is what we call tenants by the entirety. And that is a special form of ownership for married couples. And so, most married couples, if they buy a house, they're going to own the house as tenants by the entirety. And so what that means is, like the joint tenants with right of survivorship, if one spouse dies, their share automatically passes to the surviving spouse. But the difference is that, you also get what we call an asset protection benefit from that form of ownership. So if one of the spouses that's a co-owner that's held this way, for example, gets in a lawsuit, that property that's held that way cannot be used to satisfy a judgment or other liability against one of the spouses. Now, if both of the spouses have, signed an obligation, for example, the loan they took out to buy the house, well, then the house may be liable for a joint, liability of both spouses, but it is protected from, liabilities or lawsuits against one spouse. And that is unique for that type of ownership, tenants by the entirety for married couples.
If you're a married couple, you should kind of look at that deed and maybe have a conversation around what might be best for you and your family.
Yeah, absolutely. And that's something that we talk with clients about a lot, because we need to be mindful of those asset protection type issues at the same time we're doing the estate planning. And so we want to make sure that we are accomplishing both objectives, as much as possible.
Okay. Another question here in the chat. Assuming estate documents are 20 years old, are they still good?
So there's no automatic, expiration date on estate plan documents. So they could still be good, but I can just tell you from experience that the laws have changed quite a bit, regarding these different, estate planning tools. And so we do a lot of reviewing of older estate plans, and then we give recommendations on, things that are out of date or things that should be changed or updated. And, I can, practically guarantee that 20-year-old estate plan documents are going to have, some problems, or at least some things that could be improved by taking into account these changes in laws. And the other thing is, even if the law hasn't changed, your life probably has changed. And a 20-year-old document could name, someone to be your executor that's no longer alive, or, or someone, could leave everything to a spouse that you divorced 10 years ago. So, just through the passage of time and changes in your life, very often there are things that, should be updated.
Thank you for that. And I imagine it's not too difficult. You schedule an appointment with someone like you charge a few hours of your time to review it, and then you and the client make an adjudication as to whether they need to redo it or just make some edits.
Yeah, that's exactly right. So normally in that type of situation, we will start by doing a thorough review and preparing a memo outlining our recommendations and, kind of issues that we've seen. And then we'll go over, and so we'll just do that for a flat fee, and then we'll go over our recommendations with the client. And, and if they choose to implement those recommendations, that might be, making a change to one or two documents, or it might be redoing, everything in essentially creating a new estate plan, or it could be, something in between. But we'll go over all of that. And, if the client then decides to move forward, we'll let them know, what the fees will be for that next phase. Okay.
2 more questions here in the chat. Why would anyone make a plan without a trust?
Well, I would say for the vast majority of clients, I do recommend having a trust. Some clients either, don't want to pay the initial upfront cost to create it, or, or just for whatever reason, feel like it's simpler to have just a will. Although, as I hope I've, illustrated, it's certainly not simpler in the long run to just have a will. But there are some clients where they probably don't really need a trust. if they have, a very simple thing, a very simple estate, and, maybe they're just leaving everything, they don't have kids, they're leaving everything to, 3 charities and that's it, maybe a will is fine for them because, they don't really care, if there's, a little more expense and hassle on, after they're gone because they won't be here and they don't have a family that's going to have to bear that burden. So there are some situations where, either, I don't recommend a trust or the client, just for whatever reason doesn't want one. But typically, I would say the vast majority of clients, I do strongly recommend having a trust.
Yeah, I think both you and our firm, we tend to work with married couples with kids. And so the more people involved, right, the more complexity and sometimes, making that extra spend for a tool that may be adaptable to a more complex life is quite a benefit to the families.
Right.
All right, there was a question here about divorce. It says, you mentioned divorce. Does divorce terminate any benefits in the estate plan for a former spouse?
So that's a complicated question. So unfortunately, there's not a, one answer for all things. You got to go element by element. So each document is going to be affected in a different way by a divorce. Different types of assets might be impacted differently by a divorce. So you really have to, analyze it item by item and, and obviously talk to your financial planner as well as your attorney and as well as your insurance person if that's, different than your financial planner. I do have a, a piece that talks about, how divorce impacts your estate plan that I'd be happy to share with, anyone listening who would like to receive that.
Okay, great. I'll make note of that. And we'd like to send an email to all registrants afterwards. So you share that piece with me and I'll share the registrants with you as well. And we can get that piece out to everyone. There was a question earlier. You mentioned insurance. What sort of factors do you look for when you recommend, if you do recommend a client consider a whole life policy as part of their estate plan?
So, as far as specific recommendations on types of insurance policies or amounts, that's kind of beyond the scope of an attorney's services. So I refer to, your financial planner or, other insurance broker, insurance specialist, I guess I should call it. But what I do is, number one, I want to understand what insurance policies the client that I'm working with has. And, so sometimes I will be able to just, even in my non-expert opinion, say, hey, it looks like, maybe you might not have enough insurance and maybe you should talk to Jason or whoever your advisor is. To see if, having some more insurance coverage might be appropriate for you. So I guess that's one way it comes up. And then, the other thing is, as part of doing your estate plan, we need to make sure that your beneficiary designations are set up correctly so that all of this works together the way it's supposed to. And so what we will do is we will, give the client instructions on here's how we recommend, setting up your beneficiary designation on your life insurance policies. And then we will also coordinate with your advisors on that as well, if you've authorized us to communicate with them about that.
Okay, wow. So that's, it's multi-layered once you start talking about tools to add to the estate plan. And that makes sense. As financial advisors, we like to work, as I mentioned at the top of the hour, with estate planners, with CPAs, with insurance people, and make sure everyone's singing from the same music. Well, it's been a good bit of time here. There's one more question here in the chat. I'll make this the last question, and then we'll pop out. And everyone, brace yourself. You'll have our faces again as part of the video. On the topic of the revocable trust, do you find that clients have difficulty retitling assets so that they're owned by the trust during life? And I think this question is, do people get around to essentially putting the assets in the trust by retitling, or do you have to kind of be on them?
Yeah, I mean, it's definitely something that a lot of people, that say they've created a trust, years ago. And a lot of times they come to us and say, I created a trust, many years ago, but I never got around to funding it. Funding it is sort of estate planning lingo for transferring assets into your trust. So we try to, number one, emphasize the importance of it throughout the planning process. Number two, when we are delivering the completed estate plan, we give detailed instructions for how to accomplish, the retitling of assets. And then number three, as I mentioned, we also coordinate with the financial advisors. And usually if you have a good financial advisor like Jason, they're going to be on top of that. And as soon as I tell Jason, this client's estate plan is complete, he's going to know what to do to make sure that your accounts are either retitled in the name of your trust, or, for example, on retirement accounts, we don't retitle those, but you can name your trust as a beneficiary on those, similar to life insurance policies, as we were talking about before. And then the last thing I'll mention is for real estate. Real estate is transferred into your trust by signing a deed and then recording that deed in the land records at the courthouse. So that piece we do handle directly. So we'll prepare the deed, have the client sign it, and then take care of recording it in the courthouse. And so that ties back into what I was talking about earlier with the tenants by the entirety. So, we make sure that if it's a married couple, that we want to preserve that asset protection benefit. And fortunately, we can do that with a specific statute that we have in Virginia that allows us to preserve that asset protection while at the same time getting the benefit of having it in your revocable trust.
Wow, so even more perks for living here in the Commonwealth of Virginia. Ladies and gentlemen, this is David Knasel. You can see his contact information here. I'll be reproducing that in an email back out to you later, either today or tomorrow. There will be some follow-up. David, I think I speak for everyone in just thanking you for answering all of the questions, for being here at all on such a busy day and really at such a busy time for your practice. Can you leave us with one thing that all of us who are viewing and listening to you should think about when it comes to estate planning, and maybe even trying to put together or revise an estate plan here during the pandemic?
Yeah, absolutely. Thank you so much for hosting this, Jason, and thanks for everyone for attending. So I think the one kind of takeaway that I'd want to leave everyone with is, even if you don't have an estate plan, you kind of do have one, and it's a lot better to be proactive and create your own estate plan and make your own decisions and have your own wishes carried out, rather than just having a court or the law do that for you. And if you've created an estate plan a long time ago, definitely I recommend pull it out, review it, make sure it's still appropriate. There's been a lot of changes in the law and probably been a lot of changes in your life. So, again, be proactive, make sure that your estate plan is reflecting your family, your wishes, your values.
That's terrific. David M. Knasel, Chair of the Trust and Estates Practice at Protorae Law. I've been Jason Howell of Jason Howell Company. We're so happy to have experts like you, David, here. So once again, thank you for being here, and thank you for sharing all that information. Information, not advice. If you'd like legal advice, you can speak to someone like Dave Knasel or Dave Knasel himself. But this is just a resource for you to get started in that conversation. Thanks again, David.
Thank you, Jason. It's been a pleasure.
Awesome. We're signing off. The rest of you, please have a great rest of your day.